I got a question. Dealing with the devices to invest in China for foreign companies, I remember has been promoted a law dealing with the limited liability partnership in China nowadays. What about the possibility to use this kind of device in China for foreign investors?
Alex? I'm sorry, you said, sorry.
Limited liability partnership.
Oh, limited liability partnership. Basically, that type of structure is, it exists in terms of, it's not specifically a limited liability partnership. It's just called, basically, those type of characteristics are already embodied in kind of the joint ventures, the wholly foreign-owned enterprises. A lot of those aspects are in there, but the idea of a limited liability partnership, as far as I know, that's not really specifically an investment vehicle that foreigners generally are allowed to have. It's basically, as we already said, it was a joint venture, and that can be it can be basically cooperative or contractual joint venture, a wholly foreign-owned enterprise, representative office. These are the specific type of vehicles that foreigners can invest in, and they do afford a lot of the protections that a limited liability partnership have, which is basically, obviously, to protect the investors, the directors, and is recognized as a separate legal entity.
So, at this very moment, it's not possible for foreign investors to use this particular kind of device?
Yeah, partnership, not that I know. I haven't heard of the use of a partnership entity. I haven't heard of that.
Yeah, not so much. I mean, a law firm, for example, would be a partnership. Right. This law firm, for example, Chinese law firm, is a partnership. Is it limited liability? Not really. I mean, it's unlimited. A partnership in and of itself, but when you start dealing with foreign enterprises, generally speaking, they're not limited liability partnerships. In the joint ventures, like Alex was saying earlier, is a term of art. But like I said, I'm not going to talk about it. But generally speaking, you don't see it that much. You see partnerships with legal firms. You see partnerships with patent and trademark agencies. But outside, not so much. You have to take one of the other avenues generally. So there may be some exceptions.
No partnership to have limited liability.
I think that some of them say that they're limited liability, but they really, I mean, the truth be told, they don't. I mean, partnerships have really big problems, as we all know. I mean, somebody dies, then it terminates the partnership, perhaps. But limited liability partnership, I mean, legally speaking, I don't think it's limited per se.
Right, those characteristics don't exist. The whole idea of the termination of the partnership, but the legal protections in terms of like protecting the management, the investors from outside liability, from their own personal liability, that type of protection does exist.
I just got one question concerning dispute resolution. So actually in one presentation it was said that it's actually the best way to deal with dispute settlement in China is arbitration. Just one question. Do you usually do ad hoc arbitration, or there's also some sort of institutional arbitration in China? And if so, which one would be sort of recommended from this organized arbitration? And the other question, just as a sort of annex to it, does it also happen that the investors prefer to go to the normal sort of people's court, not to the arbitration?
The last question, can you repeat?
Does it also happen that the foreign investors actually prefer to go to the people's court instead of taking an arbitration?
For this question, the foreign investors, I think, always prefer to go to arbitration on the case. And
I mean, there's exceptions all over the place.
And related with the arbitration, ad hoc or institutional arbitration cases, there are institutional arbitration boards, and I think the most important one is over here. The China International Economic and Trade.
Also known as CTAG.
Mhm.
And also the Beijing Arbitration Commission, which is also quite popular. Those laws are, they have their own institutional procedural laws, which are pretty much adhered to. The Chinese contractual law is pretty liberal about that. You can, and we recommend to all our clients to have a specific clause in there in terms of any dispute that we will go to CTAG or BAC or use an overseas arbitration venue, and the Chinese are very good about honoring those type of clauses.
And Andrew, I mean, why don't you add about why is that? Or, you know, why is, I mean, just so you know, it's not ad hoc is just kind of, I guess, making it up as you go along or doing it on the fly. And the reason why it's generally not ad hoc, I mean, they try to do it ad hoc, but then why it moves into institution is what, Andrew, remember?
The primary reason that goes to arbitration in China, they want certainty. The courts are developing such a rapid pace, it's quite unpredictable what's going to happen. So in terms of arbitration, you go to CTAC or BAC simply because you can rely on that more than you could court system. They occasionally use overseas bodies like the Stockholm Chamber, your National Chamber of Commerce, but that is prohibitively expensive. Most deals in China, therefore you go local, CTAC, BAC, Shanghai or Beijing.
And what's the governing convention? Anybody know? Governing convention? Why we're doing all this generally?